Hello everyone, welcome back to Believer Science Academy Bengaluru. This is topic of the day. Today we'll discuss another episode of Supreme Court versus government laws. Recently we discussed about Supreme Court versus the government in the case of Work Amendment Act of 2025, and in today's news analysis we discussed about Supreme Court versus Government of India with respect to stubble burning, where Supreme Court said that stubble burners should be arrested, should be criminalized, and the government was like, no, we cannot do that because they are farmers. And now in another episode of Supreme Court or the judiciary versus the executive, we have question of right to religion. Why? Because of forced or religious conversion acts that have been brought by various governments of states. Okay, so the title of today's video is From Faith to Fear, the chilling effect of India's Freedom of Religion Act. India's Freedom of Religion Act. This act is not brought by the center. Instead, it is the states that have brought these laws. So there are two groups. One is a group petitioner. So first we will understand the context. A petition was filed by Advocate Ashwini Upadhyay seeking ban on deceitful religious conversions. What is deceitful according to him? Either by force, fraud, or allurement. And there was another party. One is Ashwini Upadhyay. Okay, this is party number one. The party number two was an NGO like Citizens for Justice and Peace. They argued that there are freedom of religious acts by various states, that the recent state law freedom of religious acts are in fact anti-conversion laws that restrict individual freedom. Ashwini Upadhyay wants ban on complete religious conversions, which is deceitful. But NGO argues that there is already ban on this because various state laws have already brought laws. So there is already ban on this. We have to remove this ban. So these are the two arguments put forward by the petitioner and the counter petitioner. So before we understand what the Supreme Court said, we have to understand what are such acts that have been brought by various states. Okay, we'll not go too deep into it. We just make a comparative analysis. So first one, Uttar Pradesh, UP prohibition of unlawful conversion of religion act of 2021. The grounds of prohibition of conversion was conversion by force, allurement, misrepresentation, or marriage. Who can complain the file here? Individuals, relatives, persons related by blood, marriage, adoption, or even third party with permission can go to the court. Next, burden of proof on the person who converted. Burden of proof is on the person who converted. Okay, who converted to any other religion, from one religion. Punishment is 1 to 10 years or 10 years if women from SC or ST, women or SC or ST is involved here. If you are forcibly or deceitfully converting a person belonging to SC, ST, or if you are converting a woman to another religion, then you will have punishment up to 10 years. Okay, special provisions are prior notice to district magistrate, that is within 60 days is mandatory. So if this is an example of for religious or prohibition of unlawful conversion of religious act of Uttar Pradesh, then Madhya Pradesh, which the act name changes. The name is Freedom of Religious Act of 2021. It was brought in 2021, replacing the 1968 Act. Here also prohibits conversion of by marriage, allurement, undue influence, coercion. So the grounds are almost similar: force, allurement, representation, marriage, allurement, undue influence, coercion. Almost same. Who can file? Almost similar to UP again. Family, relatives, social organizations with permissions, etc., etc. And on accused or convert. And 1 to 10 years or up to 10 years of mass conversions. Can you see the pattern here? It feels like they have been copy pasted from one state to another state. And prior notice to the district magistrate, 60 days. Marriages for the conversion declared void into initial 50-60 days period. Again, similar to UP. The time period for district magistrate notice is also 60 days only. Next is Uttarakhand, Freedom of Religious Act of 2018, which was one of the most contentious Freedom of Religion Act in recent times. Again, prohibits conversion by force, misrepresentation, and marriage, similar to UP. And family members or the persons related, similar to UP. On accused, 1 to 5 years and 2 to 7 years with respect to women, SC, ST. So the time period for jailing is lesser compared to UP and Madhya Pradesh. Again, prayer declaration to DM before conversion. Okay, you have to declare yourself or declare your case to the district magistrate before you convert to another religion. So that is the provision provided here in Uttarakhand as well. Then Gujarat, Freedom of Religions Amendment Act of 2021. 2003 law was there, which was amended in 2021. And here, what do you understand by grounds of prohibition? Marriages or the conversion by marriage, coercion, allurement, etc., etc. Family relatives can complain on the accused. The burden of proof is on the accused here, except for the UP and Madhya Pradesh. The burden of proof here is on the accused. The person who is accused of converting another person forcibly or coercively, he has to prove that it is not by force, it is not by allurement, it is by genuine. Next, marriages for conversion is declared valid here, and the punishment here is 3 to 10 years. And in Himachal Pradesh, Freedom of Religion Act 2019, force, inducement, marriage again, and who can complain? Family, relatives, guardians, and the burden of proof is on the accused itself, and 1 to 7 years, and harsher for women, SC/ST. And prayer notice of 30 days to district magistrate. And again, Jharkhand, Freedom of Religion Act of 2017, conversion by coercion, allurement, fraud, victim related person, and the burden of proof is on the accused. 3 to 10 years is the maximum punishment, and prior information to district magistrate. Next, Chhattisgarh, Freedom of Religion Act of 1968, 2000 in different districts, which has been amended over the period of times, and conversion by force, fraud, or allurement, and the victim or family can go to complain, and the burden of proof is on accused. 1 to 3 years is the maximum period of punishment, and prior intimidation to who? Again, the district magistrate. Next, Haryana, Freedom of Religion Act of 2022, recent ones. Conversion by marriage, fraud, or coercion is considered as prohibition, and family relatives can go and complain to the authorities, and the burden of proof is on the accused again, and the maximum punishment is 1 to 10 years. Marriage for conversion is void if it is proven to be deceitful. Next, Karnataka, which was one of the most debated topic in the whole of Karnataka as well as in India. Protection of Rights to Freedom of Religion Act of 2022, brought in 2022. Conversion by marriage, fraud, inducement, coercion. So almost the grounds are similar. Who can complain? Family or relatives, and the burden of proof on the accused, and the punishment 3 to 10 years. So it is almost similar to Jharkhand here. And prayer mode notice to district magistrate, marriage for conversion is void. Next, Rajasthan, Freedom of Religious Bill 2025. It is in this context that we are discussing this now, which is pending the assent stage. Similar grounds like marriage, inducement, fraud, coercion, expanded locus, and on the accused 5 to 20 years. Little imprisonment is possible, life imprisonment is possible. Bail conditions are comparable to UAPA. So this is what has made this particular bill very stringent, that the conversion attracting 0 to 20 years of 5 to 20 years of jail term, and also the bail is similar to UAPA. What is UAPA? Unlawful Activity Prevention Act, which is almost dealing with a terrorist. So you are comparing a terrorist with religious conversion, which can be genuine or malified. Despite even if it is malified, how can you how can you compare it with regard to terrorism? Okay, same bail recognitions or same bail conditions for UAPA as well as this Right to Religious Act. This is what has made it a contentious, and that is what the NGO is arguing in the court. So now, Supreme Court observations. So both parties have put their cases in front of the Supreme Court. Both parties have given their arguments. Now, what did the Supreme Court say here? Supreme Court observations. The CJI BR Gawai said that, okay, you can consider this as a forceful conversion, and you can bring certain laws. But who decides if the conversation is deceitful or not? Who has the authority? Then court's role is just to examine the constitutionality of laws and not to make laws. This is in response to NGOs. This is in response to Ashwini Upadhyaya, who wanted court to ban complete conversion. So the court said that we only examine the laws and we are not going to bring any laws which is banning a particular practice or not. So this is BR Gawai. So earlier in 2023, the courts had refused to refer the issue of forcible conversion to the Law Commission. So since it was not sent to the Law Commission, it was not included in the Law Commission recommendations. As a result, there is no law at the center. However, the laws are present at many of the states, as were declared or seen before. So, argument by the petitioner, that is Ashwini Upadhyaya. What did he say? He said that Article 25 guarantees the right to propagate religion, but not to convert through fraud or force. 6. Complete ban on such conversions. We have to understand. So, does India provide freedom of religion? Does India provide freedom of religion? Yes. So, what are the articles that deal with freedom of religion? Article 25 to Article 28. In Article 25, the Constitution of India says that individual belonging to a particular religion has a right to profess, propagate, practice or promote any religion of his choice. Okay, however, this doesn't provide conversion. Okay, you can propagate, practice, or profess or promote any religion of your choice or any religion which you are practicing, but it doesn't provide conversion. Then what is Article 26? That a person belonging to religious denomination has the right to maintain property, both movable or immovable, in accordance to the law. And in the Article 26 also has the any religious endowment or institution has the right to establish charitable or religious institutions. Charitable or religious institutions. Again, this is also a religious institution, and these institutions can manage property or maintain property, but it has to be in accordance with the law. And 27 talks about uh, religious speech or promotion cannot be taxed. Taxation is not available. However, the clause is that fees are available if you are using a public ground, which you are using any particular land for promotion of your religion, then you have to provide the fees, but it is not taxable. And in Article 28, it deals with religious instructions in schools. Religious instructions in schools. There are three types of schools, which is established by the religious institutions, established by the government of India, established by government of India or religious institutions, but curriculum, etc., is provided by government of India. So religious instruction is completely allowed here in religious institutions. So religious instruction is completely allowed in the institutions established by religious institutions. However, in the government established institutions, it is prohibited. And in religious institutions established by the religious institutions and religious minority, but it is maintained by the government of India. Here it is left to the parents. Okay, parents of the students, based on the recommendations or based on the permission, you can provide religious instructions or not. Okay, this is freedom of religion, which is provided in the Constitution of India. Do you see any provision which is dealing with conversion? Is there any provision which talks about conversion? No. So the Constitution implicitly says that the freedom of religion has the right to promote, profess, and propagate your language, but doesn't have the right to convert. No right to convert. No right to convert. No right to conversion. That is what is being upheld, or that is what is being argued by Ashwini Upadhyaya. Okay, and the arguments by NGO councils, that is Sivu Singh, with Indra Jai Singh, and Vrinda Grover. What is their argument? Their argument is that these state laws are copy paste legislations, UP, MP, Uttarakhand, etc., and Freedom of Religious Act actually restricts the freedom. That is, they function as anti-conversion law. You have to understand, one of the function is any religion they practice or any religion they like, they can practice it. So under this, though they do not have the right to convert other person, but an individual has the right to practice any religion he wants. So he can voluntarily practice, he can voluntarily convert to another religion. So they argue that this voluntary conversion or voluntary right to practice any other religion or any religion of his choice is being curtailed by these freedom of religious acts of different states. Okay, that is the argument of these NGOs. They say that it empowers third parties to file criminal complaints against the interfaith couples. Okay, as you've seen in many cases, it is not only the family or the victim, not the family members. It is also third party member with the permission of the victim here can go and file a complaint. Suppose there is an interfaith couple, a Muslim boy and a Hindu girl. They marry with their own voluntarily marry. They voluntarily marry with their own consent. Everything is provided. Everything is according to the law. And she later converts to Islam. And then this conversion based on the marriage can be raise the question in the court, or can be used as a criminal charge by any third party. Any person who is seeing that with the help of or with the permission of someone else can go and apply into the court, or can go and file a case in the police station. So this is what, if they are voluntarily converting, even then this become a controversy, even then they can be raised in the court. So this is not recommended according to NGOs. Then harsh provisions. The NGO also argues that punishments up to 20 years or life imprisonment is very harsher, and bail considerations or conditions akin to UAPA, that is the burden of proof on the accused, is provided here. And also this is similar to the terrorism. You are equating terrorism with uh, religious conversion. That too, it is not proven to be malicid or faulty. Even without proving it malafide or faulty, you are considering him a terrorist, quote unquote. Okay. Next, chilling effect on interfaith marriages, religious festivals, and observances. Okay. So it will have a chilling effect not only in the marriages or interfaith marriages, but it will have a spillover effect on religious festivals and observances as well. Next, government's position. ASD KM Nataraj opposed the sudden demand for stay, questioned the locus standi of the NGO. Okay, so we have to wait and see what the Supreme Court will say. So issues at the stake here. The Supreme Court has said that who will decide, or who has the authority to decide whether it is a malafide or deceitful conversion or not. So that's the government has to provide response to this. Issues at the stake, that is freedom of conscience under Article 25 versus state regulation. Freedom of conscience of each individual, that is he can practice, propagate or profess any religion of his choice, that is being curtailed because of anti-conversion laws according to the NGO. But state says that state has the right to regulate according to Article 25-26. State is also right here. Next, individual choice in marriage and faith versus the societal concern of forced or allowed conversions. Okay. Next, burden of proof on the convert against the principles of criminal law, that is innocence until proven guilty. So a person belongs to suppose X community or X religion. He voluntarily first converts into another religion. Why? But over the period of time they have certain issues. Now the burden of proof lies on the victim, so-called victim. So he has converted to another religion now, or she has converted to another religion. When there is an issue, then they go to the court, and the burden of proof is on the victim, and the victim can say that okay, I was forcibly converted. So here the principle of natural justice is completely broken here. Here the principle of proven until guilty is broken here. So that is what the NGO is arguing here. And the potential issues, that is frivolous complaints, harassment of interfaith couples, this will be on the rise if these provisions are accepted by the Supreme Court. Then why does it matter? This expands the debate on secularism, freedom of religion, and on individual autonomy in India as well. Okay, a person who is willingly marrying another person, etc., has to heed to the societal pressure, has to heed to the political pressure, has to heed to the religious pressures, and etc. The very question of individual autonomy, very question of right to marry persons of choice under Article 61 is being violated here. Okay. Next, raises federalism issues, that is state legislating on the religion, and could influence future constitutional interpretation of Article 25 further. Then possible parallels with UAPA and other preventive or deterrent laws where the bail becomes nearly impossible in these cases. So many of the people who have been arrested under UAPA are still waiting for the bail and are still rotting in the jail, are still rotting in the prison. Now if the same provisions are applied on victims or culprits which are deemed to have committed the forcible conversions, then they will also have to rot in jail, which is not recommended or which is not advisable. That is the argument of NGOs. We have to wait and see what the Supreme Court's further action will be here, whether it is going to remove all those laws or whether it is going to keep these laws, and we have to wait for the response of the government as well. Okay, so this is the today's topic of the video. I think I covered it in a holistic way with constitutional backing and also all the other ethical, religious, and political aspects of this particular topic. If you like the video, then please hit the like button, comment on it, and also share with your friends. And if you're new to the channel, please subscribe to the channel and click on the bell icon so that you don't miss any notification. With this, I will end the video. Jai Hind, Jai Karnataka.